My name is Chad Norell. I'm a clinical professor of law at Arizona State University. Today we are here to talk about criminal procedure. We'll be together today approximately the next 5 hours going over some of the ins and outs of, typo. Next 3 hours going over some of the ins and outs of criminal procedure that might show up on the bar exam. I know, lecture started off a little rocky, but it got better real fast, didn't it? Let me give you guys my email address. If you have any questions about my lecture today, you can email me. I'd be happy to get back to you. I don't typically answer questions about hypotheticals I have not written. For example, the hypos in your materials, I didn't write those. And I certainly wouldn't want someone commenting on my lecture that I wrote. So direct those to your local Barbary office. Otherwise, questions on my lecture, my email address is my name separated by a dot. That's Chad, C-H-A-D, dot, Noreuil, at asu.edu. I think as most of you probably know, as far as crim pro content in the bar exam, there's going to be approximately 17 questions dealing with criminal procedure. They essentially combine criminal law and criminal procedure into one subject, and they say about half the questions will be from crim pro, so approximately 16, 17 questions. Today, of course, we're going to look at some of the most often tested concepts and rules for the MBE portion of the exam. We're also going to look at what's most commonly tested for essays and look at some templates for plugging into those essays to maximize our scores. So my purpose today, guys, is twofold. Number one, to help you actually see some of these concepts as they are implemented on the exam, and two, help you actually start learning them. So this isn't just a means to an end where we're rotely filling in the blanks. We're actually here present, and we can actually remember some of these things. So look, I know it's a tough road. Our mantra for today, whatever it takes. Whatever it takes. Now, I'm not talking about going all Tanya Harding on all of your other classmates. So you're the only one left taking the exam and therefore have to pass the exam. I'm not talking about that. Well, I mean, not yet. Let's see how studying goes first, and then there's always a plan B, right? I'm talking about whatever it takes to be engaged. Because we have to be engaged in order to learn the material, and we have to learn the material in order to pass the bar exam. Whatever it takes, guys. Whatever it takes. So off we go. Roman numero 1. Quick overview of the key amendments in criminal procedure, things that we're going to talk about that will be on the exam. A, the Fourth Amendment, of course, our prohibition against unreasonable search and seizure. The Fifth Amendment, sure to be on the exam in some way, shape, or form. It's our privilege against compulsory self-incrimination and our prohibition against double jeopardy. Sixth Amendment, quite a few things to cover here. We have a right to speedy trial, right to trial by jury, right to confront witnesses, also known, of course, as our Confrontation Clause, and for our right to assistive counsel. D, the Eighth Amendment, of course, our prohibition against cruel and unusual punishment. This is not as important for purposes of the bar exam, but it might show up every now and then as something on the death penalty does come up, and what is also covered under the Eighth Amendment, not likely, however, to be on the exam, prisoner rights. All right, guys, Roman numeral 2, our big jumping off point, will be on the exam, guaranteed, the exclusionary rule. Important concept for crim pro, what is it? It is a remedy of American constitutional procedure by someone who's been the victim of an illegal search. An illegal search. Or a coerced confession. An illegal search or a coerced confession can, among their other remedies, the product of that illegal search or that coerced statement excluded from any subsequent criminal prosecution. Why? Because it is the exclusionary rule. However, they love to test you on A, the limitations on exclusion. It's a limitation on the exclusionary rule, and therefore, the evidence can still come in some way. A1. So first, exclusion, exclusionary rule, does not apply to grand jury proceedings. Does not apply to grand jury proceedings. What does this mean in practical effect? 1A, it means a grand jury witness may in fact be compelled to testify based on illegally seized evidence. illegally seized evidence. It's a limitation on the exclusionary rule. 2, exclusion is not an available remedy in civil proceedings. In civil proceedings, illegally obtained evidence can still come in a civil proceeding. 3, exclusion is not an available remedy in parole revocation proceedings. Parole revocation proceedings. And 4, double stars here. Double stars is my shorthand for the rest of my lecture. That just means this is something that's often tested. We have to know it. 4, exclusion does not apply to the use of excluded evidence for impeachment purposes. Impeachment purposes. 4A, since 1980, all illegally seized evidence may be admitted to impeach the credibility of the defendant's trial testimony. The Supreme Court told us in 1980, all illegally seized evidence may be admitted to impeach the credibility of the defendant's trial testimony. There's a little space if you want to write this in. Guys, note in particular, because they love this one on the bar exam, note in particular, Miranda violations qualify here. Miranda violations qualify here. I think that's probably pretty self-evident. Just to make sure we're all on the same page. What does this mean? Well, it means if there's some incriminating information that's obtained in violation of Miranda, well, that can still come in order to impeach the testimony of the defendants at trial. But B, note, only defendant's trial testimony may be impeached and not the testimony of other defense witnesses. It's only defendant's trial testimony, not the testimony of other defense witnesses. And 5, exclusion is not an available remedy for violations of the knock and announce rule, the execution of search warrants, the knock and announce rule. I think we all probably know what this is. The knock and announce rule is the rule that says officers can't just come barging into your house if they have a search warrant. They have to knock, announce their presence to police. We have a warrant, open up. If they do not, they are in violation of what's known as the knock and announce rule. But we know exclusion is now not an available remedy for such violations. B, related concept here, the fruit of the poisonous tree doctrine. 1, doctrine will not only exclude illegally seized evidence, it will also exclude all evidence obtained or derived from police illegality. From police illegality. All right, guys, here's your visual. This is the tree, right? The tree. This is the original unlawful police action. And then what grows from there, other things that they find, this is the fruit. Well, this fruit is poisonous. Why? Because the tree, the original unlawful police action, is also poisonous. Therefore, the fruit of the poisonous tree doctrine. 2, note, the fruit of the poisonous tree doctrine does not apply to Miranda violations. Does not apply to Miranda violations. Unless police act in bad faith in obtaining such information. In bad faith in obtaining such information. And 3, double stars here. Watch out for this one. There are 3 ways the government can break the chain between the original, unlawful police action and some supposedly derived piece of evidence. So the police can break the chain to still get this evidence to come in. A, first, the government could show that it had an independent source. An independent source for that evidence. It's independent of the original police illegality. B, the inevitable discovery. The inevitable discovery. Police would have inevitably discovered this evidence anyway, so it should come in. And C, intervening acts of free will on the part of the defendant. Intervening acts of free will on the part of the defendant. The three I's of breaking the chain between the original unlawful police action to still get this evidence that they found to come in. Guys, if you would indulge me, a little shorthand to help you remember this. To the left, as big as you can, if you would, write the number 3, capital letter I-S, what I call the three I's of breaking the chain. Why do I call them the three I's of breaking the chain? Because they all start with the letter I. A little shorthand to help you remember. Independent source, inevitable discovery, intervening acts of free will. In fact, they all start with the letter I-N. And what we're trying to do here, the government's trying to get the evidence to come in. The three I's of breaking the chain. All this leads us to hypo number 1. Hypo number 1, Hansel's illegally arrested on Friday night. Hansel, so hot right now. Hansel. On Saturday, he gets out on bail. On Monday, Hansel hires, consults an attorney. Tuesday, he voluntarily returns to the police station and confesses. Question: will that Tuesday confession be fruit of the illegal Friday night arrest, or will it be admissible? Answer: admissible. Why? This is an example of one of our three I's of breaking the chain. Breaking the chain, breaking the chain. One of our three I's of breaking the chain. This is an intervening act of free will on defendant's part. And it breaks the chain between the illegal Friday arrest and the Tuesday confession. He voluntarily goes down, gives his statement, confesses. That breaks the chain, and that evidence will, in fact, be admissible. Watch out for it, guys. The three I's of breaking the chain, so that some evidence can still come in. C, let's talk a little about exclusionary rule and convictions. 1, a conviction will not necessarily be overturned because improperly obtained evidence submitted at trial. Not necessarily. 2, on appeal, a court will apply the harmless error test. One of the two important tests in Crim Pro that we'll talk about today, the harmless error test. And 3, under this test, harmless error test, a conviction will be upheld if the conviction would have resulted despite the improper evidence. And Roman numeral 3, the Fourth Amendment, we're going to spend a lot of time here. Why? Because the bar examiners spend a lot of time here. Let's jump into it. A, the Fourth Amendment protects citizens from what? Unreasonable searches and seizures. Doesn't protect citizens from searches and seizures, only ones that are unreasonable. B, as far as arrests and detentions are concerned, 1, an arrest must be based on probable cause. Period. End of story. Arrest must be based on probable cause. 2, arrest warrants are generally not required for arresting someone in a public place. In a public place. 3, however, a non-emergency arrest of an individual in his home does require an arrest warrant. In his home. And 4, as far as the station house detention is concerned, the police need probable cause to arrest you, compel you to come to the police station, either for fingerprinting or interrogation. Fingerprinting or interrogation. Note here, guys, as an aside, they do not need probable cause to ask you to come down to the station. If you at that point consent, that's fine. But if you at that point refuse and they want to arrest you or compel you to come down with them, fingerprinting, interrogation, then they must have probable cause. C, very important concept, double stars here, are investigatory detentions, known as our Terry stops, absolutely will be on the exam. We're going to talk about it here, and we're going to talk about it again a little bit later under the purview of our exceptions to the warrant requirement. So what are we talking about? 1, so the police have the authority to briefly detain a person even if they lack probable cause to arrest. So in order to make such a stop, a Terry stop, police must have a key phrase here, guys, reasonable suspicion, a reasonable suspicion supported by articulable facts of criminal activity. Articulable facts of criminal activity. Note here, guys, a hunch is never enough, even if the hunch turns out to be correct. Even if the hunch turns out to be correct. There must be articulable facts. Oh, I saw A, B, and C, and this is what led me to the reasonable suspicion for the validity of the Terry stop. Two. Whether the police have reasonable suspicion depends on the totality of circumstances. The second major test we'll see today, as far as Crim Pro is concerned, the totality of circumstances test. 3. As far as automobile stops, police may stop a car if they have at least reasonable suspicion that the law has been violated. At least reasonable suspicion that the law has been violated. There is one exception here we see in 3A where the police do not need reasonable suspicion to stop an automobile. That exception, checkpoint roadblocks. Checkpoint roadblocks. I think we all know what this is, but just make sure we're on the same page. This is where the police set up a roadblock and they stop every car at a checkpoint. The Supreme Court has said specifically this is okay for checks for DUI and for border crossings. Don't need reasonable suspicion. There's one important point. There's a little space if you guys want to write this in. The Supreme Court said those are okay, DUI stops, border crossings, so long as they're neutrally applied. You can't just pick and choose what cars you want to actually talk to. You're going to stop every car or every fourth car or whatever it may be. That is okay as long as it's neutrally applied. And one other just additional point here, just so you guys know, roadblocks to check for drugs, not good enough. Not good enough. DUI, okay. Border crossing, okay. Drugs, not good enough. 4. As far as traffic stops and police dogs, during routine traffic stops, key phrase I want you guys to remember, a sniff is not a search. A sniff is not a search. So long as the police do not extend the stop beyond the time needed to issue a ticket or conduct normal inquiries. Here's a scenario, guys. You get pulled over for speeding, cop A comes up. Cop A says, give me your license registration. You give it to him. Cop A goes back, squad car runs your information. Meanwhile, Cop B gets out of the squad car with the canine dog. Cop B takes that dog all around your car, and the dog is there just sniffing away. No probable cause here. This dog just sniffing away. The court said, that's okay. Why? Because the sniff is not actually a search, so long as they don't extend the stop beyond the time ordinarily needed to issue a ticket, give you a warning. A couple additional points we see in 4A and 4B. 2013 cases, a lot of 2013 cases that came out in the spring term. And just so you guys know, in fact, you need to know it. Bar examiners do wait at least a cycle most of the time to test on new law, but now it is time. It has been long enough, so we need to make sure we know all the 2013 info. Here we go. Moreover, 2013 Supreme Court held, during such a traffic stop, a dog alert, the presence of drugs, can form the basis for probable cause for a search. Dog alerts, that can in fact form basis for probable cause now to search your car. B, but note, in 2013, the Supreme Court also held that the police, not having probable cause, no probable cause, cannot use a drug-sniffing dog directly outside the home of a suspected drug dealer. Directly outside the home, suspected drug dealer. Police just can't go without probable cause, and take drug-sniffing dogs all around some neighborhood and check for drugs? Supreme Court said no. All right, guys, that brings us to D. This is the only time today that I'm going to say this. Triple stars on D. Now, I know you guys all just graduated from law school, and therefore your powers of deductive reasoning are vast, immense, but 3 stars more than 2 stars. This is the most important concept for Crim Pro as far as the bar exam is concerned. Likely half of the questions as far as the MB is concerned going to come from this section, and also one of the most favored for all bar examiners in every state to test for essays, talking about search and seizure, and your model answer for giving any kind of search and seizure analysis. Here we go, step 1. First thing out of the chute we ask, is there governmental conduct? So what constitutes governmental conduct? 1A, the publicly paid police on or off duty. The publicly paid police on or off duty. Governmental conduct. B, double stars here. Watch out for this one. Any private individual acting at the direction of the public police. Here's a scenario to look out for. Police come to your roommate. They ask your roommate to search your room for drugs. That roommate's a private individual, but is now acting under governmental conduct. Why? Because he or she is doing so at the direction, the behest of the public police, and it turns that action into governmental conduct. 1. Privately paid police actions do not constitute governmental conduct unless they are deputized with the power to arrest you. Unless they are deputized with the power to arrest you. And 2, here's some examples of privately paid police, which we now know does not constitute governmental conduct. A, store security guards. Store security guards. Paul Blart, mall cop. B, subdivision police. And C, campus police. Just as an aside, guys, just trying to help y'all out, just so you know, before you go back and get all lippy with your local campus police officer, you should know that they are almost always deputized with the power to arrest you in real life. However, on the bar exam, you are to assume they are not, unless you are specifically told that they are in fact deputized with the power to arrest you. All right, guys, we have 5 steps to answering, analyzing a search and seizure question. We've just gone through step 1. Step 1, is there governmental conduct? Step 2, we ask, is there a reasonable expectation of privacy? Guys, if you would, write this word in big capital letters next to reasonable expectation of privacy. Standing. Standing. You have to have standing to object to the governmental search. How does one acquire standing? If you have a reasonable expectation of privacy, you have standing. So we're going to talk about 3 categories of standing. First, A, are automatic categories of standing. 1, if you own the premises searched. You own the premises searched. You always standing to object to the search of the place you own. 2, you live on the premises searched. Whether you have ownership interest or not. Examples, you can cover a grandchild living in a grandparent's home. And 3, double stars here. Overnight guests. Overnight guests have standing to object to legality of the search of the place they're staying. And of course, guys, what I mean by this, overnight guests who are actually invited in, right? You have a Barbary Saturday night slumber study party, right? Those overnight guests would have standing. I'm not talking about the homeless guy who breaks into your basement, has been living there without your knowledge for a week. That person would not have standing. B, here's an important sometimes category of standing. You own the property seized. B1. If you own the property seized, you have standing only if you have a reasonable expectation of privacy in the item or area searched. In the item or area searched. Of course, when I'm talking about property here, I'm talking about things such as backpacks and purses. I'm not talking about real property, land, right? Which jumps us to hypo number 2. If you get anything here, watch out for this scenario. Hypo 2. Homer and his girlfriend Marge walking down the street. Homer sees police officers walking toward them. In a somewhat nonchalant manner, Homer takes drugs out of his pocket and stuffs them into Marge's purse. Homer's arrested and later admits the drugs were his. Question. Does Homer have standing to object to the search of Marge's purse? Answer. No. Why not? Because he doesn't have a reasonable expectation of privacy in Marge's purse. Answer. No. Why not? Because he doesn't have a reasonable expectation of privacy in Marge's purse. At least, guys, not under these facts. It is possible that Homer could have a reasonable expectation of privacy in Marge's purse. It is possible, right? If the facts said that they were maybe married and it said he had access to her purse all the time because she always carried his cell phone, so he was constantly in there. And then those facts might give rise and probably would to a reasonable expectation of privacy. But just when we have on hypo number 2, not enough there. No expectation of privacy, and therefore no standing under hypo number 2. C, the no standing categories. We have a list of 9 that we just have to memorize. So we don't have enough of that to do, right? And here we go. You have no expectation of privacy, and therefore no standing for anything that you hold out to the public every day. Anything you hold out to the public every day. The following is a list of things held to the public, the seizure of which implicates no right of privacy. I got a list. Here's the order of my list that it's in. 1, the sound of your voice. The sound of your voice. 2, the style of your handwriting. The style of your handwriting. 3, the paint on the outside of your car. 4, scary one here, guys. Scary, but true. No expectation of privacy, no standing. 4, account records held by a bank. Account records held by a bank. No expectation of privacy. I know, it's not really all that scary now. You know, you just get out of law school and you're $100,000 in debt. But, you know, when you get out and start making some money as an attorney, it's a little bit scary. 5, monitoring the location of your car. Public street, you're in your driveway, monitoring the location of your car. Public street or even in your driveway. But note, guys, in 2012, pretty recent decision here, Supreme Court held that installation of a GPS device in a suspect's car constitutes a search within the Fourth Amendment. He said, well, that constitutes a search. And of course, if the police want to search, as we're going to find out here pretty quick, what do they need? They need probable cause, right? Which generally requires a warrant. So the police just can't go around and surreptitiously affix GPS tracking device to any old random person's car or even a suspect's car, right? Note here, guys, this is not inconsistent with what we saw in 5. The police can still tail a car 24/7. They can tail a car as much as they want, right? Have their undercover car, they go around following it. As long as it's in the public thoroughfares, that's okay. They cannot surreptitiously be affixing a GPS tracking device and monitor it that way 24/7. Back to our list. 6, anything that can be seen across the open fields. You know, the open fields doctrine. The open fields. And 7, anything to be seen from flying over the public airspace. The public airspace. And 8, the odors emanating from your luggage or your car. The odors, luggage or car. And 9, your garbage set out on the curb for collection. Your garbage set out on the curb for collection. All right, guys, let me pause here for a second. Let me give you some insight into the deviousness of the bar examiner's minds. This happened not too long ago. Guy's taking his garbage out, puts it over his shoulder, goes out his back door. Here's the phone ring. Has his big garbage bag, sets it against his house, goes back in, talks on the phone, forgets about taking the garbage out, goes to bed. Midnight comes, cops roll up. Cops look out, hey, there's garbage. Let's go search it. And sure enough, they search the garbage and they find all kinds of incriminating evidence against this homeowner. Does this guy have standing to object to the search of his garbage? And the answer is yes, he does. Why? Because the rule is you have no expectation of privacy, therefore no standing for what? For your garbage set out on the curb for collection. This garbage on the guy's property, leaning against his house, was not set out on the curb for collection, and therefore there was, in fact, still an expectation of privacy and standing to object to that search. Watch out for them playing with the little nuances to the rule. Make sure we know them. All right, quick review. Step 1, we ask, is there governmental conduct? Step 2, we ask, is there a reasonable expectation of privacy? We have to have that, because that equates to what? Standing to object to the actual search. And that brings us to our third step, which I have conveniently enough entitled Step 3. We ask, did the police have a valid search warrant? Guys, if you would, write this out as big as you can. The number 2, capital letter, P.S. The number 2, capital letter, P.S. The 2 P's for the validity of search warrants. A, there are 2 core requirements for a facially valid search warrant: probable cause and particularity. Probable cause and particularity. And of course, they both start with P. Let's flesh this out a little bit more. A1. So the standard for probable cause, our rule, if you will, the standard, a fair probability contraband or evidence of a crime be found in the area searched. A fair probability. 2, as far as our particularity requirement, the warrant must state with particularity the place to be searched and the things to be seized. The place to be searched and the things to be seized. And 3, as far as warrants and the use of informants, A, if an officer's affidavit or probable cause is based on informant information, its sufficiency is determined by the totality of circumstances. Second time here, today we've seen the totality of circumstances test. The totality of circumstances. And B, an informant's credibility. How many times have they used Huggy Bear in the past? And how many times has he given good information? Informant's credibility and basis of knowledge. Basis of knowledge, all relevant factors in making this determination, dealing with our totality of circumstances test. Basis of knowledge. Well, how did Huggy Bear know this? Oh, well, he used to run with this guy. He used to be in the guy's organization. Whatever it might be. Credibility, basis of knowledge. C, valid warrant can be based in part, notice the bold, on an informant's tip, even though that informant is anonymous. Anonymous cannot solely be based on an anonymous tip. Cannot. But it can be in part, and that can be what gets the ball rolling. You can have an anonymous hot tip line. Someone calls in, leaves an anonymous tip. Is that going to be enough? Nope, that's not enough. But if the police go and independently corroborate some of these things, then that can be enough to form the basis for our probable cause. All right, guys, that jumps us to B, a quick revisitation of our no-knock entry. No-knock entries permitted in the execution of search warrants if exigent circumstances exist, B1. an officer need not knock and announce. Knocking and announcing would be dangerous, futile, or inhibit the investigation. Dangerous, futile, or inhibit the investigation. And 2, for the biggest fear of inhibiting the investigation, destruction of evidence. These are exigent circumstances where the police are not required to knock and announce their presence. In fact, exigent circumstances exist. All right, guys, quick review. Step 1, we ask what? Is there governmental conduct? Step 2, we ask what? Is there a reasonable expectation of privacy, which we have to have in order to have standing to object to the governmental search? Step 3, we just went through. That's easy. Let's start 2 Ps. Make sure the warrant is actually valid. But what if at this point the warrant is no good? Then we go to step 4 to see if we can save this evidence in some way, which jumps us to step 4. If the warrant at this point is not valid, we ask, does an officer's good faith defense save the defective search warrant? A. General rule is an officer's, key phrase here, guys, good faith reliance. Officer's good faith reliance on the search warrant overcomes defects, the probable cause or particularity requirements. Pretty easy for step 4, right? Good faith reliance. But because it's the bar exam, we have B. 4 exceptions. A good faith reliance on defective search warrant. 1. The affidavit underlying the warrant is so lacking in probable cause. No reasonable police officer would have relied on it. It's so lacking in probable cause. No reasonable officer would have relied on it. This jumps us to hypo number 3. An affidavit support search warrant states the officers, quote, have it on good information and do believe that there are drugs at Lindsay's house, end quote, but states nothing else. Question, is this affidavit legally sufficient to establish probable cause? The answer, no, it's not. There's nothing here about why the police think so or where they got this information from. Why the police think so, where they got this information from. Therefore, it's an example of an affidavit underlying the one so lacking in probable cause, no reasonable officer would have possibly relied on it. You don't get the benefit of the good faith defense. Our next exception, 2. The affidavit underlying the warrant is so lacking in particularity. So lacking in particularity. No reasonable officer would have relied on it. Well, that's not too bad. The first 2 exceptions out of our 4 exceptions are just so lacking one of our 2 Ps, probable cause and particularity, for the validity of search warrants. And next, you don't get the benefit of the good faith defense. If 3, police officer or prosecutor lied to or misled the magistrate when seeking the warrant. Lied to or misled the magistrate when seeking the warrant. 4, if the magistrate is biased, therefore has wholly abandoned his or her neutrality, don't get the benefit of the good faith defense. All right, guys, we only have 5 steps. Breaking down, analyzing any type of search and seizure question, whether that be analysis on an MBE question or what we actually put down on paper in order to maximize our score for a search and seizure essay type question. We know those 4 steps. Step 1, we ask, is there governmental conduct? Step 2, is there a reasonable expectation of privacy, which we know equates to standing, which we need in order to object to the governmental search. Step 3 is easy. Step 3, 2 Ps. Step 3, 2 Ps. Check the validity of the warrant. Probable cause, particularity. Step 3 are 2 Ps. And step 4, we just saw, if at this point, maybe the warrant is not valid, then we see if an officer's good faith defense can still save the evidence to get it in some way. But what if, at this point, the warrant is invalid and actually cannot be saved by step 4 of the officer's good faith defense? We go to step 5, are exceptions to the warrant requirement. If a warrant is invalid, cannot be saved, or what sometimes happens on the exam guides, if the police never had any warrant at all, then our last step, the all-inclusive, all-encumbersome exceptions to the warrant requirement, 5A. First, let's talk about the search incident to arrest. The search incident to arrest. A couple things here. A1, first, the arrest must be lawful. The arrest must be lawful. If the arrest is unlawful, then the search is unlawful, period, end of story. 2, the arrest and search must be contemporaneous in time and place. Arrest and search must be contemporaneous in time and place. Which jumps us to hyper number 4. Defendant's lawfully arrested in Philadelphia at noon. Police later search him in Pittsburgh at 5 p.m. Question: is this a valid search incident to arrest? Answer: no, it's not. Easy one. Why isn't it valid? Not contemporaneous. Not contemporaneous in time and place. And 3, we also have what's known as the geographic scope limitation. So what can be searched, guys, under a search incident to arrest theory? The person and the areas within the person's wingspan. The person, the areas within the person's wingspan. Rationale here, can search these areas too. Why? Because these are the areas that this person could reach in and grab a weapon, or maybe reach in and destroy some evidence. So you can search the person and the person's wingspan. 4, double stars here. Some more recent Supreme Court activity dealing with search, incident to arrest, and automobiles. Here's the rule we need to know. The police may search the interior of the auto. Incident to arrest. The interior, not the trunk, guys, the interior of the auto, incident to arrest, only if A, the arrestee is unsecured. The arrestee is unsecured and still, therefore, may gain access to the interior of the vehicle. Or, 2 parts to our rule, and this conjunction is an or, not an and. Very, very important. Always pay attention to our conjunctions. Junction, what's your function? Hooking up words, and phrases, and clauses. Hooking up words and phrases and clauses. Or, B, the police reasonably believe the evidence of the offense for which the person was arrested may be found in the vehicle. Police reasonably believe the evidence of the offense for which the person was arrested may be found in the vehicle. We learned all this in the very recent Supreme Court case of State versus Gant, which I have encapsulated in hypo number 5, ripped from the headlines, dun dun. Hypo number 5. Police arrested the defendant for driving on a suspended license shortly after he stepped out of his car. The defendant was then handcuffed and placed in a squad car. Police then searched the passenger compartment of the defendant's car, found cocaine, a jacket in the car. Question: is this a valid search incident to arrest? Well, it certainly used to be under the old law of New York versus Belton. The Supreme Court took great lengths to say we are not, in fact, overruling, even though they did. But they announced a new rule, which we saw in 4A and B above, and they said it is not a valid search incident to arrest under the facts in hypo number 5. It is not a valid search incident to arrest. Used to be New York versus Belton. So if you remember that case, please vanquish it from your mind as if it never existed, because that's essentially what the Supreme Court did. Don't get me started. Specifically, the Supreme Court said arrestee was secured, right? If you're handcuffed, back to lock squad car, you're secured. So under prong 1 of our new rule, which I'll call our Gantt rule, arrestee clearly secured, can't search under there. And under our rule in prong B, there is no way you could find evidence of the offense of driving a suspended license in the car. There's no way you could find that in the car. Why? You already had a license, you already knew it was suspended. It wasn't going to be as if there's multiple licenses confirming, in fact, driving on a suspended license. Therefore, neither prong of Gantt was met. Our new rule, A and B, and therefore not a valid search incident to arrest. All right, guys, look, this is ripe to be tested. This is something we need to look out for. I think it's about time. Gantt, not too long ago, but long enough, the bar examiner's salivating to test you on this. So I have a couple of hypotheticals here, things to look out for. Hypo 6 first. While on patrol in her squad car, Officer LaGuerta sees a car swerving across the center lane, driving erratically. Officer stops the car and approaches the driver's side window. The man in the car and the car itself reek of alcohol. The man's speech is slurred. After administering a sobriety test, which the driver failed, the driver is arrested, handcuffed, placed in the back of a locked squad car. Officer LaGuerta then searches the man's car and finds drugs and an illegal handgun. Question: will these items be admissible at the man's trial? Answer: likely yes. Likely yes. A lawful search incident to arrest here. Why? Well, clearly not valid under prong 1, right? Because the arrestee was secured. So can't search under prong 1, but we have an either-or proposition, so we check out prong 2. And here we probably can search under prong 2. Why? Because the car itself reeked of alcohol. The car itself reeked of alcohol. Thus, it's reasonable that there's evidence in the car of the offense for which the person was arrested, the DUI. If the car itself reeked of alcohol, then it's reasonable for the officer to think, well, there's evidence of the offense, the DUI, to be found in the car, and therefore valid under our second prong of our Gantt rule. However, 2 important follow-up questions to hypo number 6, which I've listed here. Things to look out for. 1. So does it matter that what was found during the search, hypo number 6, drugs, illegal handgun, was different than what gave rise for the officer to search in the first place, the alcohol? And the answer is no. Doesn't matter. And here's always what I want you to remember about crim pro. So long as the search itself is valid, so long as the search itself is valid, any contraband found will be admissible. Any contraband found will be admissible. Guys, the focus is on the validity of the searching itself, not what was found. Search is valid, any contraband going to be admissible. And 2, little follow-up here. What if my hypo I just outlined, hypo number 6, what if the car didn't reek of alcohol and it was just a straight DUI arrest? Would the officer have grounds under prong 2 of Gantt to search the interior of the vehicle? And the answer is yes, and no, and yes, and no, and no. At least these are the lower court decisions that have come across this actual scenario. So the answer is we don't know. If it's a straight DUI arrest, we're not really sure, so therefore not likely to be tested. However, we do know that if the car itself reeked of alcohol, then likely going to give rise to the validity of the search, likely is going to be evidence of the offense for which the person was arrested, the DUI in the car. All right, one more. Let's flesh this out a little bit more. Hypo number 7. While on patrol in their squad car, Officers Ponch and John observe a car speed past them going well over the posted speed limit. Ponch approached the driver's side window and asked for the driver's license and registration. While pulling out his license, a bag of crack cocaine and a pipe falls out of the man's pocket, which Ponch observes. Ponch asks the driver to step out of the car and informs the driver that he's under arrest. While reading the driver's Miranda rights and attempting to handcuff him, the man breaks free and runs off. Officer Ponch chases after him. Officer John, now with bad knees, does not join the chase, but instead searches the driver's car. Officer John finds recently stolen jewelry under the passenger seat. Question: is this a valid search incident to arrest? Answer: yes. Clearly valid under prong 1 of our Gantt rule. Why? The arrestee is unsecured. Clearly valid under prong 1. Why? Because the arrestee is unsecured. Therefore, he can still gain access to the car. Remember, guys, anytime an officer says, you're under arrest, turn around and handcuff you, whatever it might be, once he says you're under arrest, you are now an arrestee. If that person runs off, that person can always double back around to the car, gain access to the car, maybe grab a weapon, maybe destroy evidence. Therefore, clearly valid under prong 1 of Gantt, and possibly under prong 2 of Gantt, although it's never been specifically decided, similar to our straight DUI arrest that we talked about. For crack cocaine in someone's pocket, is it reasonable to think there's going to be more crack in the car? Maybe. It's a closer call. Your job is to make sure you give the rule, apply facts to that rule, and clearly here, valid under prong 1. All right, guys, one more thing to talk about, an important concept before we take our first break, and that's under C. It's been popping up on a lot of exams across the various states. Most states recognize the community caretaker exception to this rule. The community caretaker exception. By the way, sometimes it's called emergency aid exception, which I think may be listed as such in some of your barbering materials, emergency aid exception. So the community caretaker emergency aid exception to this rule justifies a warrantless search if an officer faces an emergency and threatens the health or safety of an individual or the public. Health, safety, individual, or the public. All right, guys, so this is a case that recently came out of the Ninth Circuit. Doesn't really matter where it came from. Bar examiners look at all kinds of cases. It's a community caretaker. You don't need to write this down. It's not in your materials. But last thing before we take a break, community caretaker exception. Basically what happened, cops get a bunch of reports of the blue Ford pickup truck in the park. The passenger is shooting at signs in the park. Cops go to the park, and they see what they're pretty sure, based on these calls, is what the same blue Ford pickup truck, and it's parked. There's no one in it. Cops go up, see that the windows are rolled down halfway. No one's in the car, but they look in, they see there's what looks to be a gun holster in the passenger seat. But they're not really sure because there's a newspaper covering up half this gun holster. Cop reaches through the window without a warrant, pulls back the newspaper. Lo and behold, there's a gun holster with a gun in it. Cop sees this without a warrant. Valid? Court said, yeah, valid. Why? Under the community caretaker exception for the public health and safety, any kid could have done the same thing in the park, been a danger to himself or to others. Community caretaker exception, watch out for it. It's its own exception to the warrant requirement. It's its own exception, but it has been applied to automobiles a lot in the aftermath of the Gantt decision. All right, guys, that brings us to a good stopping point. Let's take 10, come back in 10 minutes. Welcome back, everyone, to fun-filled hour number 2. Welcome back. Simmer down now. Simmer down. Simmer down. I know it's always tough to jump right back into the substantive part of the outline, so I thought I'd take just a second to step outside of Crim Pro and talk about the bar exam generally. I think that there's 2 really important things that are essential to passing the bar exam. Number 1, I think it's absolutely critical that it makes sure that and if you don't make an absolute, sorry guys, just wanted to mess with y'all out there watching on video land. You know, don't want to come to live lecture, watch on video. Yeah, I'll teach you 1 or 2, right? No, I kid. I love all the video land people. Look, guys, there really are 2 most important things. Wish I could be there in the room with you, though, to see who's like, what 2 important things? What he was saying? No, I'm kidding. There really are 2 important things. One is you absolutely positively have to know the law, right? If you don't know the law, you cannot pass the exam. But number 2, which I think is just as important, you have to know how to take the exam. You could be the person who studied the most, who knows the most, and still come up short if you don't know how to take the exam, how to write things down on paper on your essays in a way to maximize your score. Just like we talked about the purview of our steps analyzing search and seizure. You have to put down all 5 of those steps, right? What I call stating the obvious. You must state the obvious to get credit for the obvious. Don't go through the steps in your head. Put them down on paper. Know how to take the exam to maximize your score. All right, guys, we left off our outline talking about our exceptions to the warrant requirement. We talked about the search incident to arrest first. Now, in our outline, brings us to our second exception, B, the automobile exception. Here is what we need to know. 1, in order for the police to search anything or anybody and fall under the automobile exception, they must have probable cause. They must have probable cause. Period. 2, no if, but only if. For searching anything or anybody, the police have probable cause and they can search the entire car. The entire car. This includes the entire interior compartment and the trunk. Different, guys, from our search incident to arrest where you do not get into the trunk. Moreover, if there's probable cause, the police may open without a warrant any package, luggage, or other container which could reasonably contain the item. Key phrase here. Could reasonably contain the item. If they had probable cause to look for that package, luggage, or other container, it's owned by the passenger or the driver. Let's see if we can flesh this out a little bit with a couple hypos. Hypo number 8 first. The D.C. police have over 30 reports that drugs are being sold in the back of a car. Police know everything about the car. You know the make, model, license number. They know nothing about the drug seller. D.C. police officer, aware of these 30 reports, sees the cargo by driving lawful speed. Officer stops the car, but he does not arrest the driver. He orders the driver out of the car and he searches the car. Officer finds a box in the passenger seat, opens the box, and finds drugs. Question: will the drugs be admissible? Answer: yes. Under the auto exception, no warrant here, don't need one. Why? We have an exception, the auto exception. The officer had probable cause here. The officer had probable cause to search this vehicle. Guys, if you have 30 reports, make, model, license number of car, these reports saying someone's selling drugs out of this particular car, that's enough for probable cause. And thus you can search what? The entire car, including any package, container, could reasonably contain the item, probable cause, the officer had probable cause to look for in the first place. Again, hypo number 8, answer, yes, will be admissible. Why? Auto exception, probable cause existed. Hypo number 9, same basic facts as hypo number 8, but instead of drugs, police have probable cause from these multiple reports again. Stolen TVs being sold out back of a van. Again, officer stops the van, searches it, and finds a small 6-inch by 6-inch box on the passenger seat. Question: if the officer opens the box and finds drugs, will the drugs be admissible? Answer: no, not here. Why? Because the 6-inch by 6-inch box couldn't reasonably contain the stolen TV sets. Different than the situation with the drugs, hypo number 8. Here, answer no. The 6 by 6-inch box couldn't reasonably contain the stolen TV sets. And 3, another little nuance to our auto exception. The probable cause necessary to justify the warrantless search of an auto under the automobile exception can arise after the car is stopped. But, big but, the probable cause must arise before anything or anybody is searched. But the probable cause must arise before anything or anybody is searched. Which jumps us to hypo number 10. A Denver police officer pulls over a car to give a speeding ticket. The car was stopped, and the police officer noticed the car, driver, and passenger fit a description just broadcast of people involved in the theft of auto parts. And then the police officer looks in the back seat and sees lug nuts, wrenches, and other things that suggest the theft of auto parts. The officer sees the auto parts and searches the trunk without permission, and they find drugs. Before trial, defense counsel moves to suppress all evidence. The judge should rule that A, both the auto parts and the drugs are admissible. B, neither the auto parts nor the drugs are admissible. C, only the auto parts are admissible. D, only the drugs are admissible. What is the best answer? Well, let's see what's going on here, guys. Couple different things. First of all, is there a warrant? No. Is there an exception? Is this an exception based on our automobile stop? And the answer here is yes. Because why? Because there's probable cause. There was probable cause on the auto exception, and therefore, clearly the auto parts are going to come in. Why? Because the probable cause can arise after the car is stopped, which it did here. But it has to arise before anything or anybody is searched. And here there was no search taking place. And once we have, under the auto exception, our PC, then we can search the entire car, including the trunk, and therefore the drugs also come in. Therefore, correct answer here is A. Both the auto parts and the drugs are admissible. And you guys might be wondering to yourself, wasn't there a search because the officer looked in and saw the lug nuts and wrenches and things suggesting the theft of auto parts? And that answer is no, absolutely not. Why? Because it's not a search. If the officer is legitimately there, which the officer was, and the officer sees something in plain view. Therefore, no search took place. Probable cause arose after the car was stopped. Once you have PC, you can search what? The entire car. Correct answer here is A. Both auto parts and drugs are admissible. Number 3 in our list, which we just talked about conveniently enough, plain view. 2 key phrases I want you guys to remember for plain view. Let's jump into them. C1. To constitute a valid plain view seizure, the police officer must be legitimately present. Legitimately present. First key phrase. The location where he or she does the viewing the item seized. And 2, it must be immediately apparent. Immediately apparent that the item is contraband or fruit of a crime. 2 key phrases. Legitimately present, immediately apparent. Remember those 2 phrases, can't go wrong. Hypo number 11. Police officer, for no reason, runs to the front door of your apartment, sees a big pile of marijuana in plain view. Question, is this a valid exception to the warrant requirement? Answer, no, It's not valid. Why? Because the officer was not legitimately present when he or she did the viewing. Also watch out for this, guys. Watch out for them using the phrase plain view, but then the plain view exception doesn't actually apply. They love to do that to try and trip you up, right? So here's a quick example. Let's say the police combing the area for some kind of suspect. They knock on someone's door, and a question actually says, the person opens the door, and the police officer looked down and in plain view saw a paper sack. And then opens up the paper sack and sees all kinds of contraband. Admissible? Answer, no. Why not? It was in plain view. Because a paper sack, it's not immediately apparent that is contraband or fruit of a crime, even though it said it was in plain view. Watch out for that. Them trying to trip you up on that. Remember those two phrases, legitimately present, immediately apparent, can't go wrong on plain view. Number 4 on our list, consent. Exceptions to the warrant requirement. Here's what we need to know. For consent to be valid, the consent must be voluntary. Consent must be voluntary. Hype number 12. Police come to your house and say, we have a warrant. Mind if we look around? You respond by saying, okay, go ahead. Drugs are found in your house, you're arrested, but the warrant subsequently turns out to be invalid. Question. Is evidence still admissible because you consented to the search? Answer, no. Police saying they have a warrant negates consent. Police saying they have a warrant negates consent. Police saying they have a warrant negates consent. They say they have a warrant can never be voluntary, valid consent. And 2, double stars here, third-party consent, deals with who has the authority to consent. Our rule. Where 2 or more people have an equal right to use a piece of property, either consent to its warrantless search. However, if both people are present, one person consents to the search, the other does not consent, then the one who does not consent controls. One who does not consent controls. Shirt is not black. One who does not consent. Please come to your place. You and your roommate are there. Ask to search. You say yes. Roommate says no. Roommate controls. One who does not consent controls. E has promised a revisitation of our Terry stop. Now we're going to add a frisk. Why? Because it's fun. E, stop and frisk, exception to our warrant requirement. Let's jump into it. E1. So hopefully remember this. A Terry stop is a brief detention for the purpose of investigating suspicious conduct. Investigating suspicious conduct. 2, the legal standard for stopping reasonable suspicion, that key phrase we learned back in hour 1. Reasonable suspicion. 3, the reasonable suspicion standard is less than the probable cause standard. And 4, a Terry frisk is a pat down the outer clothing, body to check for weapons. A Terry frisk, a pat down. So guys, this issue is sure to be on the exam in some way. So I have a series of hypotheticals, each more devious than the last, to try and flesh this out a little bit. Let's start with hypo number 13. While on patrol in a high crime area, a police officer notices a man standing in the corner wearing a red bandana and red shoes, typical colors of the Blood street gang. The officers pull over and observe the man for 15 minutes, and the man never moves from the street corner. Suspecting him of being a drug dealer, police approach him, say they'd like to ask him a few questions. The man says he needs to leave the area and refuses. If the police persist, is this a valid Terry stop? Answer, no. Not enough for reasonable suspicion here. Answer, no. Not enough for reasonable suspicion here. Just so you guys know, though, in dicta, the Supreme Court, under these basic set of facts, said it's getting close. So under these basic facts, It's getting close to reasonable suspicion. In dicta, the Supreme Court says this, but not quite enough yet. Getting close, but not quite enough yet. Hypo 14, based on actual case as well. New York police officers observed two teenage boys pushing a baby carriage down the street at midnight, and they noticed that where the baby was supposed to be, there was a computer terminal. True story, can't make this stuff up. Only New York, right? When the boys see the officers, they quickly turn the opposite direction and speed up their pace. Question: can the police lawfully stop the boys? Answer: yes. There's enough for reasonable suspicion here. Clearly, answer: yes. Enough for reasonable suspicion. Hypo 15. Officers stop a man on reasonable suspicion. So we know that going in. We don't have to analyze this prong. And sometimes they'll do this. They want to test you on another nuance to the rule. They pat him down, feel something in his pocket, which is the same shape as a gun. And in fact, it turns out the object is a gun. Question: is the gun admissible? Answer: yes, so long as the stopping is reasonable, as we know it was here because we're told so in the question. So long as the stopping is reasonable and there's a reasonable belief the man might be armed and dangerous. Answer: yes, so long as the stopping is reasonable, as we know it is here, and there's a reasonable belief that the man might be armed and dangerous. And of course, that is going to be admissible. Hypo 16. Officers stop a man on reasonable suspicion, pat him down, feel something in his pocket. Officers reach inside and pull out evidence of a previous crime reported in the neighborhood, but it's not a weapon. Question: is the evidence admissible? Answer: it depends. Answer: it depends. And here's the rule I want you guys to know, remember, and put down if you get this on any type of essay. If the officer reasonably believes, by the plain feel, key phrase to remember here, we're dealing with our Terry stop and frisk, the plain feel that something's a weapon or contraband, then it will be admissible. Again, our key rule: if the officer reasonably believes by the plain feel that something's a weapon or contraband, then it will be admissible. And guys, note here, when I say plain feel, I mean literally, it's just a plain feel. If the question says the officers manipulate the contours, reach inside the pocket, manipulate the pocket, that is not going to be valid. It's only the plain feel, weapon or contraband, will be admissible. 5. Note: if probable cause rises during an investigatory stop, the detention can become an arrest. The officer could then conduct a full search instant to that arrest. And 6, as far as our auto stops are concerned, if a vehicle is properly stopped for a traffic violation, the officer reasonably believes that driver or passenger may be armed and dangerous. The officer may, 1, conduct a frisk, of the suspected person, and 2, may search the vehicle. So long as it's limited to the areas in which a weapon may be placed. All right, guys, that brings us on our long and winding road to the last grouping of our exceptions to the warrant requirement. F, evanescent evidence, hot pursuit, and special needs searches. I'm going to start with evanescent evidence because I very much enjoy saying evanescent evidence. F1. Evanescent evidence is evidence that might disappear quickly. The police took the time to get a warrant. Example here, which has shown up on the MB before. A police officer can scrape under a suspect's fingernails without getting a warrant. She took time to get a warrant. The the defendant might go and wash his hands. Therefore, that evidence would go away. All right, guys, look. This is often tested. They like the scraping of the fingernails. That's a common one. But here's how we always remember it. Evanescent evidence is fleeting evidence. That's what the word means. Evanescent evidence, fleeting evidence. And here's an easy way to remember that. You can think of evanescent evidence as fleeting from the singing group, Evanescence, which was basically a one-hit wonder and very fleeting, right? You remember that one song, like, wake me up inside, can't wake up, wake me up inside, can't wake up, save me from this boring day, or whatever, that particular song, I can't remember the lyrics exactly. Evanescent evidence, fleeting evidence, guaranteed you're now always going to remember that. All right, guys, Supreme Court, busy. I see our little note here in 2013. Supreme Court held the officers need a warrant before taking a blood sample for a DUI arrest, if it's practical to do so. In 2013, Supreme Court reversed course, some law that had been standing since the 1960s. And they basically said, guys, that the taking of a blood sample under this set of facts, the DUI set of facts, it's no longer a per se exigency. No longer a per se exigency. It could be based on the particular facts, but it's not automatically anymore. Thank you for clearing that up for us, Supreme Court. Now we're even more confused. 2, as far as our hot pursuit of a fleeing felon, a rule of thumb, if police are not within 15 minutes behind the fleeing felon, it's not a valid hot pursuit exception, 15 minutes. Best illustrated by hypo number 17. Hypo 17, a cab driver with a police scanner in his cab hears a broadcast of a fleeing felon in the scanner. Cab driver sees the person run the house. Cab driver calls the police and they arrive about 8 minutes later. Police enter the house without a warrant. They find a gun, a whole bunch of bloody clothes, all linking the guy to the crime. Question, is the evidence admissible? Answer, yes, under the hot pursuit theory, exception to the warrant requirements. They didn't have a warrant to enter the house, still valid under the hot pursuit theory. And A, note, if the police are truly in hot pursuit, they can enter anyone's home without a warrant. Any evidence they see in plain view will be admissible. Will be admissible. So guys, literally, if the police are chasing a felon, and the felon runs through your front apartment door and you're sitting there packaging up drugs to put yourself through law school, and the police chase the felon, look over and see you, that's in plain view, they're now legitimately there. And that can be admissible against you. Why? Because it's in plain view. Note to self, lock your front doors and don't allow felons to run through your house. I'm not saying, but I'm just saying. 3. Inventory searches. Before incarceration of an arrestee, the police may search 1, the arrestee's personal belongings. The arrestee's personal belongings. And or 2, the arrestee's entire vehicle. Personal belongings. Or 2, the arrestee's entire vehicle. Just so we know, guys, this, by the way, includes any closed containers within that vehicle. So we know, includes any closed containers in that vehicle. Police can search these things because they want to inventory it so you can get it back when you get out. But while they're in their inventory, if they find drugs, too bad for you. Inventory search, no warrant required. 4, double stars here. Supreme Court been busy the last decade or so. Public school searches. A, public school children engaged in extracurricular activities can be randomly drug tested. Public school children engaged in extracurricular activities can be randomly drug tested. Guys, when I say extracurricular activities, it runs the gambit, right? We're not just talking about testing the football team, the basketball team. We're talking about extracurricular activities, testing the pom-pom squad or the chess club, right? You know, because we don't want our chess club members all roiding up on HGH, right? Oh, my pawn will kill your queen. Oh. Yeah. Your pawn can't move. My pawn can. Come on, roid. Right. Also would cover a school dance. Why? It's deemed an extracurricular activity. Public school children want to go to a school dance. They can, in fact, be randomly drug tested. B. As far as warrantless searches of public school children's effects, such as purses and or backpacks, we're talking about when we say effects, it is permissible. Investigate violations of school rules. Purses, backpacks is permissible. Investigating violations of school rules. And C, guys, if you get anything on any type of essay that gives you factual scenarios as to what happened during the actual search, you need to know this rule. A school search will be held to be reasonable only if, one, it offers a moderate chance of finding evidence of wrongdoing, and two, the measures adopted to carry out the search are reasonably related to the objectives of the search, and three, the search is not excessively intrusive. All right, guys, those are our 5 steps for analyzing or putting down paper any type of search and seizure. MBE question, make sure you go through that analysis. On an essay, make sure you go through the 5 steps. Now look, you don't need to write down all the exceptions to the warrant requirement. Only those that are in play are the ones you need to write down and actually analyze. But we need to know our 5 steps. Make sure you know them. We do, however, have one more Fourth Amendment issue to discuss, and we see that in E, and what's wiretapping and eavesdropping. E1. All wiretapping and eavesdropping requires a warrant. Yeah, right. Good one, government. Yeah. I used to say that, and then a couple years ago I'd say, guys, don't get me started on the Patriot Act, okay? Here's our general rule. Now with things that have happened recently, let's just say, that's our general rule, and that's what we need to know for the bar exam. All wiretapping and eavesdropping requires a warrant. 2, we have exceptions to the eavesdropping rule, right? Government listening in, the eavesdropping rule. That's known as the unreliable ear and the uninvited ear, where there's no warrant that's necessary. Let's talk about the unreliable ear first, 2A. So everybody in society assumes the risk. The person whom he is speaking by the consent, the government monitoring the conversation, or will be wired. And therefore, there's no Fourth Amendment objection on the basis that there was a warrantless search. Or will be wired. Guys, I am not talking about the phone here, right? Every state has different rules as far as phones are concerned and whatnot. We're not talking about phones. We're talking about someone in person. You go to Starbucks, and you're out with your friends at Starbucks, and you're talking about some things that you did, and lo and behold, it turns out that friend is wired, and the government is listening to this wire in a van parked down by the river. That is going to be admissible against you, or at least there's no Fourth Amendment basis to object here. It is known as the unreliable ear. You run the risk and assume everyone will be wired. And while I'm on this point, as an aside, this is most likely not going to be on the exam, but I think everyone needs to know it. Guys, all police cars are wired, okay? All police cars are wired. So if you ever find yourself thrown to the back of a squad car, don't be muttering stuff to yourself under your breath. Oh, I knew I shouldn't have been commingling client funds like that. Oh, because that will be admissible against you. At least there's no Fourth Amendment basis for objecting there. Practical knowledge for the bar exam and for real life. B. A speaker has no Fourth Amendment right if she makes no attempt to keep the conversation private. No attempt to keep the conversation private. So here, guys, visual, think Khloe Kardashian out having lunch somewhere, blah, 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 blah. And no one trying to keep that quiet. If there happens to be a government agent at the next table, then that's going to be admissible without any warrant needed, or at the very least, there's no Fourth Amendment objection. That's known as our uninvited ear. No warrant required. All right, guys, that takes us to the end of our Fourth Amendment. Clearly the most important topic for the bar exam. Gone through the things to look out for, things most often tested. But the second most often tested thing, both for the MBE, which we're going to get multiple questions on the MBE here, and also for essays, that is Miranda. We are in Roman numeral 4, confessions and Miranda warnings. 1. When Miranda warnings are required, the suspect must give the following information. He's right to remain silent. You say you're in court. Right to attorney. Can afford an attorney. Won't be so point if you so desire. We all know this, of course, one of the staples of our Constitution, right? Yeah, Miranda. We all know this from 3 years of law school or 13 years of law and order, which is why I pretty much learned everything I know about criminal procedure. Look, guys, the only thing I test here we see in 2. The warnings need not be verbatim. The warnings need not be verbatim, so long as the substance of the warnings is conveyed. So if an officer says you have the right to remain quiet instead of using the word silent, no big deal, right? But if the officer forgets that, say, you have the right to an attorney, well, that is a big deal. But they need not be verbatim as long as the substance is conveyed. 3. The trigger for required Miranda warnings, custodial interrogation. Custodial interrogation. Guys, again, Miranda is often tested. Let me make a point here. There are 2 separate and distinct analyses when dealing with Miranda: custody and interrogation. Each has its own separate and distinct rule, and therefore its own separate and distinct analysis. So let's jump into with custody first. 1. The legal standard for custody. You are in custody if, at the time of interrogation, a reasonable person would not feel free to leave. Would not feel free to leave. Guys, write this word, big capital letters, objective. It's an objective standard here. An objective standard. 1A, so in making this determination, a court will determine whether the situation presents the same inherently coercive pressures as a station house questioning would. The same inherently coercive pressures as a station house questioning would. And B, this not free to leave standard covers being in a police car, being in jail. It's pretty obvious, right? You're in custody in those situations. But you could also be in your home or in a hospital bed, depending on all the facts and circumstances surrounding. And 2, in 1984, the Supreme Court said that probation interviews and routine traffic stops are not custodial. Probation interviews, routine traffic stops are not custodial. Which means what? It means the police can ask you questions without giving you the Miranda warnings. Anything you say can be admissible against you. That's our custody. We also have interrogation. 1. Under the Fifth Amendment Miranda Doctrine, interrogation defines any conduct where the police knew or should have known that they might elicit an incriminating response from the suspect. Elicit an incriminating response from the suspect. Guys, there's a little space here if you want to write this in. So let's make sure, look out for a couple things because it comes up a lot. Look, interrogation is more than just asking questions, okay? They love to try and trip you up on this. If you get an essay and they're trying to test you on this concept, most of the time, police officers are going to ask multiple questions. Hey, you like sushi? Hey, what do you think of this weather we're having? Where'd you hide the dead bodies? If you just come down your essay and you say, here, there's interrogation because of the police questioning, You just lost points. Why? Because it's your job to tell the examiner you know which specific question triggered the interrogation prong of Miranda. Watch out for that. Comes up a lot. Be specific whenever in doubt. And 2, double stars on 2. Love, love, love this one, the MB. It's an all-time favorite. Miranda warnings are not required prior to the admissibility of what's known as a spontaneous statement. Spontaneous statement. This is not my outline. You don't need to write this down, but I think it might help you memorialize this. Actual true story. Actual true story. A friend of mine gets out of law school, goes and hangs a shingle, does a bunch of criminal defense work, has a repeat client. This particular client's home one day, hears scuffling up the front steps, pulls back on the curtains in the front window and sees the cops. Goes to the front door, throws the door open just as the cops are getting ready to knock on the door. The guy says, whoa, whoa, whoa. I know you guys are probably here to talk about that stolen Buick that I've got parked out back. Cop says, actually, we're here for a police charity fundraiser, but now we'd love to talk to you about that stolen Buick that you've got parked out back. That's an example of a spontaneous statement where no warnings are required, and that statement can and did come in court against that particular client. All right, guys, again, they love this one. Let's flesh it out a little bit more. Hype number 18. Hype number 18. Donna was arrested, taken to police headquarters. She was given Miranda warnings. Donna indicated she wished to phone her lawyer, was told she could do so after her fingerprints had been taken. While being fingerprinted, however, Donna blurted out, quote, paying a lawyer is a waste of money because I know you have me, end quote. At trial, Donna's motion to prevent the introduction of the statement she made of being fingerprinted will most probably be A, granted, because Donna's request to contact her attorney by telephone is reasonable and should have been granted immediately. B, granted, because of the fruit of the poisonous tree doctrine. C, denied. The statements are volunteered, were not the results of interrogation. Or D, denied, because fingerprinting is not a critical stage in proceeding, requiring the assistance of counsel. What is the correct answer? Well, guys, you probably know, at its core, the MBE is a process of elimination type of exam. But every now and then, there should be an answer choice that jumps off the page of you, and I think, hopefully, after we've talked about, one of those did here. Do you guys see where it says Donna blurted out? Go ahead and circle that phrase, blurted out. Watch out for that. They love to insert that phrase for Crim Pro. If they are testing you on Crim Pro and you see that, they're testing you on what? The spontaneous statement, where no warnings are required and that statement's going to be admissible. Therefore, hopefully what jumped off the page of you, correct answer here is C. Denied, statements are volunteered and not the result of interrogation. Just so you guys know as to the other answer choice and why they are not the best, as far as A is concerned, there's no rule that says you have to be given your attorney immediately when you ask. It's okay for them to go ahead and finish the fingerprinting. No big deal here. B, I hope you can see that it has nothing to do with the fruit of the poisonous tree doctrine. There's no original unlawful police action, let alone something that stems from that. And D, guys, is actually a true statement. Fingerprinting is, in fact, not a critical stage in the proceeding requiring the assistance of counsel, but that doesn't cut right to the heart of the analytical matter, whereas C does. Why? Because we're talking about a spontaneous statement, volunteered, not the result of interrogation. Therefore, the best answer is, in fact, C. All right, guys, if you find custody, you find interrogation, what does that mean? That means the police must give the warnings, which leads us to the next thing, the Miranda Waiver. A. So a Miranda Waiver must be knowing and voluntary. Knowing and voluntary. B. Courts will employ a totality of circumstances test in making this determination. Again, important test in Crim Pro, the totality of circumstances test. All right, guys, let's talk about invoking your Miranda rights. First, 5A. Invoking the right to remain silent. 1. Our rule, if you will. Invoking the right to silence must be unambiguous. must be unambiguous. 2. The police may reinitiate questioning after the defendant has invoked the right to silence. They wait a significant amount of time. Defendant is re-Mirandized. Defendant is re-Mirandized. The questions are limited to a crime that was not the subject of the earlier questioning. Questions limited to a crime was not the subject of the earlier questioning. And B, as far as invoking the right to counsel, 1, request for counsel can be invoked only by an unambiguous request. An unambiguous request. Just like we saw invoking the right to remain silent. And 2, if the accused invokes his right to counsel, all questions must cease till 1, the accused is given an attorney, or 2, the accused initiates further questioning. It's the accused initiates further questioning. Three, recent Supreme Court case. However, if there is a break in custody, for example, in this particular case, being released into the general prison population, the police can come back and ask the defendant to waive his Miranda rights after 14 days. After 14 days. Glad we're not arbitrary and capricious here, Supreme Court. Yeah, 14 days sounds good. Come back and ask then, okay? Which jumps us to a couple hypotheticals. Hypo number 19 first. Charlie's detained and properly given Miranda warnings. Charlie remains silent for over 2 hours and eventually says, "I know where the murder weapon is, but that's it." Police then continue to question Charlie. Charlie finally says, "Maybe I should get a lawyer now." Police completely ignore this, continue to question Charlie, who eventually confesses that he, in fact, did kill the victim. Before trial, defense counsel moves to suppress all statements. The judge should A, exclude the statement about the murder weapon, but admit the confession. B, exclude the confession, but admit the statement about the murder weapon. C, exclude both the confession and the statement about the murder weapon. Or D, admit both the confession and the statement about the murder weapon. All right, guys, a couple things going on here. Let's talk about the statement first. If merely sitting in silence, even if it's for hours, is that invoking your right to silence? Nope. Supreme Court told us in 2010, to invoke your right to silence, you must speak. And when you do so, it must be unambiguous. Therefore, the first part comes in. And what about the second thing that's going on here? Well, Charlie says, maybe I should get a lawyer. Well, isn't that invoking his right to have his lawyer and the police have to stop questioning? Nope. Why not? What's our rule? The request for counsel must be unambiguous. This request, not even a request, maybe I should get a lawyer, that at best is ambiguous. Maybe I should get a lawyer. Maybe a good idea if I get a lawyer now. You guys think I need a lawyer? All examples of ambiguous requests. Therefore, correct answer here is D. Admit both the confession and the statement about the murder weapon. Again, correct answer D. As in duh, winning. Miss you, Charlie. Yeah. Hype number 20. Police detain Barney Gumble and bring him to the station for questioning. After rigorously questioning about a murder, Barney says, "Hey, there's beer in that ashtray, but I'm going to talk to my lawyer now." Police, I'm sorry. Sorry, I thought I said Brian Gumble. Different voice, sorry. Police continue to interrogate Barney, and Barney finally makes incriminating statements about the crime. Will Barney's incriminating statements be admissible in his criminal trial? Well, let's see what's going on here. Let's see, the rigorously questioning, he says, "I want to talk to my lawyer now." That is an example of an unambiguous request, right? But then the police continue to interrogate him, and he makes incriminating statements. Question, will the incriminating statements be admissible in his criminal trial? Well, this is an easy one, right? Au contraire, mon frère. The answer is, it depends. Huh? What? I said the answer is, it depends. The statements are clearly inadmissible in the prosecution's case in chief. The statements here, guys, clearly inadmissible in the prosecution's case in chief. We know why. We just went through it. Because it was obtained in violation of Miranda. Barney asked for his attorney. They ignored it, kept questioning him. Clearly inadmissible in the prosecution's case in chief. But remember back in hour number 1, first thing I said, double stars here. A confession obtained in violation of Miranda may be used to impeach the credibility of defendant's trial testimony if he takes a stand. Information, confession statement obtained in violation of Miranda may be used to impeach the credibility of defendant's trial testimony if he takes a stand. Our first double star, one of the limitations on the exclusionary rule, and I said, remember, watch out for Miranda violations. They qualify here, right? That's what's going on here. So you guys might be thinking, Professor Norell, I don't know, that's kind of unfair, because the question doesn't say Barney's going to take the stand. Oh, I know. And the bar examiners know too. What does the call of the question say? Will Barney's incriminating statements be admissible as criminal trial? If you answer that question in an essay, and you just said, no, they're obtained in violation of Miranda, you just lost points, right? Why? Because the full breadth and depth of the question leads you to need necessarily to say, hey, they could, however, come in if, in fact, he takes the stand. Why? Because of the limitation on the exclusionary rule. Watch out for that, guys. Make sure you're answering as specifically as you can. All right, guys, last thing before we take our next break, I want to talk a little bit about B, the Fifth Amendment right to counsel versus the Sixth Amendment right to counsel. Look, before we jump into this, let me say something. This used to be one of the things the bar examiners love to test you on. It used to be questions all the time on the MBE. Is this a Fifth Amendment right to counsel, or is this a Sixth Amendment right to counsel? Because depending on if it was a Fifth Amendment right or a Sixth Amendment right, that person had actually different rights. But recent Supreme Court activity has blurred the lines between the Fifth and the Sixth Amendment right to counsel. Blurred lines. So it's even caused some Supreme Court justices to say, I'm not even sure if there's a difference anymore based on our recent activity between the Fifth and the Sixth Amendment right. Okay. So having that as our backdrop, I would be remiss if I didn't tell you where the Fifth and the Sixth Amendment rights came from and where they basically are now, which we're not really that sure. But just in case you would get a question, is a Fifth Amendment right or a Sixth Amendment right, here's all you need to know. B1. So the court created Fifth Amendment right. Court created Fifth Amendment right to counsel arises when a suspect invokes his Miranda rights. Request an attorney. Fifth Amendment, Miranda. Just remember that. Fifth Amendment, Miranda. 2. The Fifth Amendment right to counsel is not offense-specific. Thus applies to the entire process of custodial police interrogation. Fifth Amendment right, not offense-specific. Thus applies the entire process